I'm John Miller, founding attorney of Rock Solid Law. Thanks for joining this morning for our continuing series of webinars. This morning, we're back on the estate planning subject matter. We really enjoyed the big estate planning overview, why estate planning is about you, last week, and had a lot of participants, and are thankful that we've been able to consult with some people after that one. This morning, I would like to go over what we call our quick check. The idea behind it, what it's supposed to let you know, and it's only 10 questions, so I'm going to go through the questions and let you know the reasoning behind each of them and why we think that they're important in considering whether to do your estate plan, right? 95% of Americans need an estate plan. Probably only about 50% have an effective one. And unfortunately, we're seeing that about 80% of Americans end up going through the probate process. And there's a typical diminution of the value going to your heirs or the charity of your choice or whatever. Between at least 10%, and on average more like 60%. So if you left $1 million, maybe your family's only going to get 400,000. There are lots of ways around that, figuring out how to avoid creditors, including our major creditor, the Internal Revenue Service. So lots and lots of things we can do in the estate planning process. This morning's talk, though, is just what is the quick check? It's actually something we used a couple of years ago. We'd kind of gotten away from it, but it's a way that people can, without even talking to me or a member of my team, kind of look at their overall picture and see whether an estate plan is good for them. And so for those of you that have joined us this morning, thank you. And here's a little peek behind the curtain as to what that's about. So the quick check is, the overall is, it's 10 questions. You do it on a survey, and I forget the name of it, but we'll send each of you that are on the call a link in case you'd like to do it. And literally, it should take you 2 minutes or less because they're all yes or no, and they're pretty softball questions. I call it a 50-mile-an-hour fastball right down the middle of the plate. So it starts out with, are you married? That should be pretty easy. I know there are people that are going through the divorce process, and that's an easy one because if you are, you need to seriously think about your estate plan because clearly you're having a major life change. The time to look at updating an estate plan is always during a major life change: marriage, divorce, kids, somebody dies, make a lot of money, lose a lot of money. Major life changes are the times that you should be thinking of estate plan. So are you married? Yes or no? The next question is, do you have children? So estate planning is for people who have children or who don't have children, but I will say that people who have children absolutely need estate planning. And on the in the case of someone that has only minor children, really important that we have a pre-need guardianship. So just in case you're not able to take care of those kids, who's going to do that? Otherwise, you kind of are leaving a pretty big mess for whoever is trying to clean up after you. If they're adult children, a whole nother set of circumstances, right? Because after they're 18, you no longer have the ability to do those things you could do for them before legally. So we may want to consider them giving you a power of attorney for you to be able to do that for them. Maybe a healthcare surrogate if they're off at college, so you could communicate with the physicians in the event that they have some treatment. And also, thinking down the road, a lot of people don't want to spoil their adult children by having them inherit too early. We typically make decisions differently in our 20s than we do in later decades. So I always say that when I started my practice, most people were distributing in their 20s to their children in their 20s. Now I'm seeing it stepped out with the final distribution often in the 40s. And it creates a safety net and also can create good work habits. We also have people that put other things in there, like they have to test clean for drugs. They have to have a job. Really, sky's the limit on what you can think of to make those distributions happen. So that's what's behind the do you have children question. Do you own a home? So estate planning is important for 95%. because the 5% that are below, seriously below the poverty line, there's really not going to be any implications financially or with property transfer at their death in most instances. But if someone does own a home, maybe they don't have a lot, but they inherited it from their parents or grandparents, maybe they inherited the family farm, those people are in real need of estate planning. So if we know someone has a home, that goes on the side of thinking they may need estate planning. So do you have investment or rental properties? So we're just stepping up one more step. Folks that do have properties other than their homestead, right, are likely to need to consider some asset protection, to consider some ease of transfer. There are all sorts of other issues that come with do you have investment or rental property that make us believe that you may be a good candidate to consult regarding estate planning. With regard to retirement savings, right? So if you have qualified plans or retirement savings of any kind, there typically is a need to consider how those are going to be treated. And they're a special category. So they're different than all of your other investment accounts. And we work with your financial planner, insurance agent, etc., to make sure that those are properly transferred. Are they a Roth or not? So with a Roth, you're looking at non-taxability, right, on the distribution side, and also that protects the tax to your next generation. So a typical qualified retirement plan is not a generational planning device as far as the tax that your heirs, your children, are going to have to pay when they inherit it. They often inherit it during their primary earning years, and that means they're paying the highest tax rate on those funds that you have worked so hard to pass to them. Only about 5%, I think I said, of retirement funds are non-taxable at this point in America. And just so you're thinking about it, I mean, we all know there's an election coming up, and pretty much the thinking is, regardless of the result, there's going to be an increase in taxes next year. Either party wins. They've got programs that they've done that they haven't paid for. And one of the wiser pieces that I have read, have heard continually, is that retirement funds are one of the things they're going to look at because there is so much retirement that we Americans have put away. And that's a source that those in Washington would look at for taxation. And I'm telling you, if you think it can happen, the Secure Act was passed with a Republican president and a Republican control of the Senate, which was a tax increase this year. What it meant is, instead of being able for your heirs to take distributions throughout their predicted lifetime, they have to take those distributions within 10 years. Bring you back to what I just said about those being their primary earning years. So they're probably going to pay taxes at the maximum rate of their lifetime on those. And, you know, we've got a pretty big deficit spending going on in Washington right now, and they're going to pay for that somehow. So we predict that retirement funds are something we're going to look at. So question number 5, obviously, is the one where we really think that people are going to need to get involved. Just an aside, that's the first 5 questions we asked. You have probably picked up on it. The yes answer, an accumulation of yeses, is going to tend to indicate it's a good idea to consider estate planning and get some professional advice about that. You know, the very first one of those, are you married? Yes, no. You know, a lot of people that are not married really need estate planning too. So it's not definite, but we've tried to kind of build 10 questions that will just put the thought in your mind of what you might need to do. All right, moving on. So the next one, we just talked about retirement investment accounts. Then the next question is about Pardon me. Next question is about other trading or investment accounts. So do you have money in the market? Are you trading? And then, of course, we want to seriously think about how that would impact your estate. Of course, tax consequences, but also the real thing is ease of transfer. Because one of the greatest voluntary taxes you can pay is to have your estate go through probate. That's going to reduce for a couple, your entire estate by probably at least 12% what's going to be left behind. So if you've got money in the market, if that's where you've invested, something we definitely want to look at is some estate planning. Time out for a little sip of water. And for those of you that are new to us, there is a chat button at the bottom of the screen. And at the end, I usually reserve a few minutes to answer any questions you might have. You know, I'm on the quick check today, but if there are estate planning questions generally, maybe that you didn't get to ask last week or that are, you know, burning in your mind, feel free to put those in as well. Kind of the rules are, if it's something generally applicable to everybody, I think it's a good idea to answer it here online. If they're really specific facts that are just to your family situation, maybe better if we do that in a privileged conversation. As you know, conversations with your attorney are privileged, and only this between you and your counsel, and nobody else in the world is entitled to know what you talked about. All right, we're going to go on to the seventh question. Do you have a favorite charity or organization? And as an estate planning attorney of 25 or 30 years, I love this question because one of the things that I say regularly is that Rock Solid Law is my ministry. It is our outreach to the community, and we try to help better the communities and be a good corporate citizen and participate in our community. One of my favorite things in estate planning is when there is a family who wishes to consider charity as part of their plan. It's not necessary, but I will tell you that it is altruistic, but not 100%, because there are positive tax ramifications we could consider as a part of those charitable gifts that we build into your plan. So if someone does have a favorite charity or organization that is part of their values, part of what they care about leaving behind for their legacy, we definitely want to include that charity. And they need to think about that, because we know how we can control what is unspent during the lifetime after you're through with it. And if it is your intent to get it to your favorite charity in the best way possible. Question number 8. Do you have a plan for your children if you can't care for them? I know we had children before, but this one is so important, particularly the folks with minor children. It's just impossible to tell you how urgent it is that every parent have a plan to take care of their children when they can't, and we make it legal. Because maybe your best friend would be the perfect person, but if that is not documented, those children are going to be raised by somebody else. And, you know, in our mobile culture, you know, I'm raising kids on the beach, and they surf and skate and everything else. And my family lives in Tennessee, North Carolina, and Ohio. And if we weren't able to take care of them, it's very likely that they are not going to grow up beach kids anymore. As sad as that is for them, that's the reality of who would be best to raise them. So that question is intended to get folks thinking in those terms. People say, yeah, but I only have adult children. Well, I haven't gotten there yet, as you can see above me, but my friends tell me that at 18, they don't suddenly leave the house, and you're not suddenly not taking care of them financially anymore. So if that question's intended to think in terms of taking care of your children literally throughout your life and their life. Number 9, do you own a business? Really important, and that's how I got into estate planning 25 years ago. I came up as a litigator, as a trial lawyer. I enjoyed representing my clients at court, but I found that I really enjoyed more the transactional work where I'm helping people build a business rather than arguing in front of a judge after something has gone badly. So I redirected my practice toward small business representation, and in representing my small business owners, I learned that I couldn't do an adequate job of that unless I also had the estate planning piece, because in representing the future transition of the business, it really significantly impacts the family when we're talking about small business. So a quarter century ago, I brought estate planning into my practice, and in the last 8 or 10 years, it's just gotten more and more sophisticated as we have the great pleasure of working with, common people, but also more and more with high wealth individuals, which allow us to work on some more interesting, more sophisticated strategies and things. I see there's a question, just so you know, that was number 9. I'm on number 10. So after I get through with number 10, I will take that question and respond to it. So that is number 10. Does your existing estate plan need updating? Wow, well, here's the one that is so often the case. You know, a lot of times we have a family, we get married, we might have children, and realize, whoa, I need to do a will. Maybe I did a revocable living trust and my other documents, and 20, 25, even 30 years later is the next time a lot of folks pull those documents back out of the drawer and realize how completely outdated they are. So I would argue that an outdated plan is almost as useless as no plan at all, because it may cause a lot of confusion. A lot of folks, when they're young, are going to do a will-based plan, and by the time it's needed, a trust-based plan would have been significantly a significantly better option. So we'll review that plan. Oh, and another thing is laws change, right? So you need to look at what's the difference in the law from the time that you made that plan. A very easy example for Floridians is the power of attorney statute changing. Let's see, I guess we're about 9 years ago now. So any plan that is over that, absolutely the power of attorney needs to be updated, in my opinion. Additionally, we are finding that there are an awful lot of people who think they did their estate planning, maybe did a trust plan, but never funded the trust. Funded means changing the assets into the trust. And I hate to break the news if you don't know it, because if you didn't fund your trust, you've got an entirely ineffective plan. You're going through probate anyway. You're going to pay those heavy costs of probate in terms of money, time, and stress on your heirs. I know a lot of people, one of the main things I hear is, I want to make it easy after I'm gone. And candidly, you make it easy after you're gone and your legacy is celebrated. Make it difficult after you're gone, and all of that difficulty that the heirs go through is associated with your legacy, really. So let's see, that was 10. So I've gone through the 10 questions, and the key that we look at really is if you only have about you only answer 1 to 3 correctly, you're at low risk. You're in pretty good shape. I'll say at 3, depending on which 3 they are, you might want to have a look with a professional for some advice on that. If you're 4 to 6, you're at a reasonable degree of risk, and I would recommend you definitely sit down and talk to somebody. And then 7, 8, 9, 10, you're at a high risk of things not really going the way you would have hoped they had. You're in that large majority of Americans, candidly. And we would highly recommend that you get a consultation with a professional, which segues me into, of course, we would like you to consider consulting with us at Rock Solid Law. There are a couple things that I think you will find different about us. Our planning approach is values-based. We're not just checking boxes with you. We really want to know, as you probably have discerned from this quick check, what your values are, what you care about. I've found that almost everybody cares about something greater than themselves. And if that's you, then we would love to sit with you and hang on a few minutes, and I'll tell you a little bit more about that. I want to go forward. You know, this is a quick check, right? It's only 10 questions. It doesn't tell us a lot of detail. But another thing that differentiates my law firm's practice from others is we have an objective opportunity evaluation. I'll say it one more time. Objective opportunity evaluation. We break that down. Objective. You know, our life is made up of the decisions we make at crossroads, right? I mean, when important things come along, it's a crossroads. And if you haven't done what you need to do for your estate planning, you're at that crossroads until you make a decision. Candidly, by not doing anything, you're making a decision. And the decision is they're probably going to be a big mess after you're gone, and things are not going to go the way you would have wished they had. There is an issue with taking advice from people who have something to sell you, right? So when we say objective, most of the things we evaluate are not things that this law firm provides. We're looking at your insurances, we're looking at your investments, we're looking at your future potential taxes, and just giving you an analysis of what's out there. So yes, there are a number of fantastic financial planners out there in the world, and they are good people to get advice from, but it also is a great idea to get some objective advice elsewhere. The opportunity is just, we literally have, in addition to human input and knowledge, algorithms that we can run to see how various strategies will affect your future. And those are the various opportunities that are available to you. And obviously, you come out of the end result with an evaluation and some advice, but also a written evaluation of where you are and where you might want to be going in the future. So that's not what we're here to talk about, but I just wanted to mention it. And I'm going to take questions now, but with regard to you taking the quick check, if you haven't done so, I'm going to have my team send you out a link so you can do so again. And if you take the quick check or not, I'm going to go ahead and throw it out there and make an offer to everybody that's online now to waive our fee and have a consultation. The fee for the consultation is waived, not for the entire plan, right? So that's about a $425 value. And I will tell you, I consulted with somebody yesterday, told him exactly what he needs, and he's actually moving away, so he's going to be consulting with somebody else, or probably having his plan done with somebody else. I'm okay with that because he's moving from the people who haven't planned for a lifetime, and the guy's probably 60, to somebody that's going to be planned. So we moved somebody from the negative side to the good side. We didn't get to do it ourselves, but I'm okay with that. And sometimes people choose not to work with us for whatever reason. I'm okay with that. But of course, we would love to at least sit and talk, go over what your needs might be with you. I'll say it again also at the very end. Next week's webinar will be on fraud in real estate transactions and the safe escrow program, which we use to defeat fraud in the real estate market. So that may be interesting to some of you. That will be on October 1st. We'll get a flyer out to everybody on that. Now, I'm going to have a sip of coffee, and I see at least 4 questions, and we'll start taking those. Also means the glasses go on. When I had my LASIK, they said you will eventually need glasses, and the time has come, my friends. The time has come to talk of things, of shoes and ships and sealing wax of cabbages and kings. Anybody know who wrote that? That's just your bonus question today. Give me just a second. I wanted to look something up. I got a little something for you at the end today that's a little different. Got to get away from the Commodores for the out music. All right, I'm pulling up the questions and answers. Oh, well, that's just a statement, but I'm going to follow up on it. Thank you so much for that comment. One of our participants is taking care of a 90-year-old mother and is the only child. You know, it's like everything in life. There comes that day when you're no longer capable of taking care of these needs. And so you don't want to wait a day too late, right? There's going to be a day when you could have done it and a day when you couldn't. We call ourselves the sandwich generation. We're taking care of our parents as they age and our children as they're getting raised. So I love that because I get to take multi-generational planning into consideration. I'm glad you get it. You know, hopefully your 90-year-old is still cognitively aware and can make life easy for you, because you're going to have to be the one that cleans it up. I will tell you an interesting fact. It is the attorney who is, as an officer of the court, makes the determination whether someone is competent to execute the documents. Of course, if there's a case where we're not sure, we can send them for an evaluation, but I have not had that occur in my life. And typically, it's pretty clear whether somebody is oriented to day, place, time, who they are, etc. So I hope not only that you get it for your mom, but your mother, but also for yourself. And I'd love to discuss the generations of your family and see where we go from there. The next is a great question, sir. Why or why not would you put your personal residence in a revocable trust? Well, for attorneys who know what they're doing, we can move a residence, the homestead, into the revocable living trust without losing homestead status. In Florida, and if you are interested in this subject, there's a video on it at our videos link at our website. In Florida, we have one of the strongest homestead protections in the world. So it's unbelievably vital that you do nothing to lose that homestead protection, okay? And you can goof up a deed and lose it. So please, please, please work with a competent real estate professional that has studied real property law and can do that for you. The reason to put it in there would be ease of transfer. Typically, spouses hold that together, meaning that when the first one dies, the second one automatically owns it. But the problem is then after the death of the second one. So we need to get that property transferred into the trust, so there'll be a successor trustee who will properly distribute the homestead according to your wishes after you're both gone. Excuse me. I did have a situation yesterday or recently where somebody was going to be selling their home within 6 months and moving away. And my recommendation was don't undertake the small expense of moving it. It really doesn't cost much to move a homestead, but it does, in my professional opinion, make the most sense to do so. Next question is, glasses time. What are the consequences, good or bad, of putting your privately held business in a trust? So, wow, thank you for that question, because that's how I got into estate planning and why I wanted to be able to take care of our business owner clients by being able to provide the estate planning piece as well. Typically, we will recommend putting the ownership, whether membership or shareholder, of a small, closely held business into the trust. Same reason as typically it keeps it out of probate. but it's really important, vitally important, that the attorney doing the work inside of the business, as well as the attorney doing the estate planning, are coordinated or are the same person. Because if for instance, operating agreement of an LLC said one thing and an estate plan said something else, you might be setting up litigation. So it'd be really important not to do that. The trust can transfer the business on sale as readily and easily as the individual can. There is no additional layer of asset protection for the ownership of the LLC, but I don't really believe it's necessary as long as it's a multi-member LLC. So I know that there is one excellent CPA on this call, and I'm unaware of tax consequences outside of your sub-S election or not that would affect putting the ownership in the trust. So in most instances, we would recommend putting a privately held business in a trust for probate avoidance, and there may be an extra layer of privacy in that as well. And I see there's something on the chat bar, which is different from the questions. What parts can you do without an attorney? How many documents total are needed? So, wow, that's a very individualized question. And candidly, the number of documents changes with the needs of the client. But let's just run them down: a trust, a will, a power of attorney, a healthcare surrogate, a HIPAA release, and a directive to physician or living will. What was that, 7? So I would say there'd at least be that many. You know, you can go to LegalZoom or you can get forms online, and it's better than nothing. But it is not an individually crafted plan that I think has a lot of hope of carrying out your wishes. So maybe your hospital has a living will, or hospice does, that you would choose to use. Seen a lot of messed up powers of attorney. Healthcare surrogate you can probably get from your doctor. I'm not sure about that. I don't know if they provide those or not. I would just highly recommend not doing a will, and certainly not a trust without legal counsel. I know they probably still sell wills at Office Depot, and you can get them online. But I began practicing law in 1984, and I have seen many, many wills that were improperly executed or just done in a way that is contrary to law, and that causes litigation. So what you want to avoid is probate, and what you want to avoid is litigation. I do see that a member of my staff responded regarding what level of wealth you're talking about, and so that's completely something that needs to be taken into consideration when you're thinking about drafting documents. So, what can I do without an attorney? You can do anything without an attorney. I've got somewhere around here a holographic will. That's a handwritten will from a German immigrant from like 150 years ago, which is absolutely hilarious. He says, have the preacher dig the hole to find the can of money, but watch him the whole time and count it when it comes out, and things like that right there in his will. So anybody can do anything by themselves. I would highly recommend that nothing beyond a living will or healthcare surrogate be done without legal counsel. And even those, you're talking about the care of yourself. So I would say to you that it's really the care of ourselves as we age is one of the best ways we can take care of ourselves through estate planning. So I would just highly recommend that that you consider strongly, whether it's worth it in your overall picture. Typically, estate planning is less than one week family vacation. So, it's just a question of what your priorities are. And one of our quests, one of our missions is to help people check that box, get the basic estate plan in place so that they don't leave a mess with their heirs. All right, let's see. I am going to click the question and answer one more time. Looks like I've answered everything that's on there, and I took care of the chat box as well. Thank you for joining us this morning to talk about the quick check and estate planning. This video will be on our website at rocksolidlaw/videos. Again, I'll reiterate, for watching this or taking the quick check, if you want to send the quick check to somebody you know, I will offer you a 1-hour consultation, which is a $425 value, and I'll waive the fee. The fees we make our fees when we plan with somebody and execute the plan. And I would suggest that generally everybody on this call needs to go through that exercise. Finally, I will leave you with the fact that our next webinar is October 1st, and it will be on fraud in real estate transactions and how to protect yourself from it. We use the Safe Escrow program, which is an amazing opportunity to keep fraud out of our programs. I want you to know that on October 15, I believe I've got that date correct, we will be doing the full estate planning webinar again. And the title of that one is going to be Isn't It Time? So I'm going to leave you with another song from 1977, John Waite and the Babies, Isn't It Time? Thanks for joining me this morning. I am John Miller, Rock Solid Law.